Hear ye. All the appeals of the state of Michigan is now in session. The Honorable Christopher M. Murray, the Honorable Seema D. Patel, and presiding the Honorable Philip B. Mariani. All persons having business herein draw near to the attention, and it shall be heard that state of the United States, state of Michigan, and this honorable. Thank you.
Hey, good morning. Oh, that's nice. You did better than yesterday. So on behalf of myself, Judge Murray, and Judge Patel, welcome to the Michigan Court of Appeals. This is day 2 of panel 4 of this court's June 2026 case call session. And we are ready to begin our 10 a.m. session for the day. Before I start, just a few quick reminders. Counsel, when you approach the podium, please be sure to put your appearance on the record. And if your clients happen to be in attendance today, just please let us know that as well so we can welcome them. Counsel, I'll ask that you please keep your own time. I'll do my best to help you with that, but I'll leave it to you as your primary responsibility. And if you are, we have some cases that are consolidated today. If you're dividing time with another attorney, just please let me know that up front as well. By way of reminder, if you have a case with both sides endorsed, it's 30 minutes maximum for either side. Max 15 if it's only one side endorsed. Please know that we are very familiar with the relevant facts and law for your cases. We've spent a lot of time with them up in preparation for this. So please focus your time here on your most salient points or matters that you think require particular clarification. And of course, any questions that we may have for you. Lastly, and importantly, because these proceedings are being recorded and will be posted publicly online, please, for cases that involve children or other protected or vulnerable persons, do not use their names in identifying them or discussing them. Please just use their initials or other non-personally identifying way to refer to them. Okay, that's it for me. Oh, one more thing. Counsel, if I mispronounce your name or your client's name, please do correct me. It's important to get that right. That is it for me. And I think we're ready to call our first case for the morning. And that's item number 15, People v. Woods. 374-165.
Morning, Your Honors, again.
Morning.
May it please the court, Tracy Gittleman for Mr. Woods this morning. Mr. Woods is not attending. I'd like to hit on some salient points as Your Honor has suggested. I will remind the court that this is a de novo review regarding the motion that we filed and the request to withdraw a plea, because there are multiple reasons and mistakes that occurred during this plea and then thereafter on the plea, and with the first sentencing and they adjourned the sentencing and then had a sentencing a second time. Mistakes continued on after the plea. A main mistake that I will say isn't necessarily immediately touched on in the brief, but is cited with law after my review, is that at the plea taking, the judge did not advise my client that he could be facing a mandatory consecutive sentence of parole because he was on parole. He did advise him that because he was on parole, by being found guilty in this case that I'm presently on, that he could be facing a higher maximum, being consecutive, mandatory. And I did quote law on that, but I wanted to just cite another case that's directly on point, which granted the plea withdrawal in the Court of Appeals. And it is an unpublished case. The only reason I'm using an unpublished case is because it has every case in it is published. And it is a January 25 case. I'm sorry, a 2021 case. But it cites all necessary published law. And that is People versus McMichael, M-C-M-I-C-H-A-E-L, docket number 351869, decided November 18th, 2021, for the proposition. One big reason here is that plea withdrawal should be granted or permitted should my client choose to take that route, because he was never advised by being on parole he was facing a consecutive parole sentence if he was violated. Now, secondly, other mistakes. He was never, well, I'm not going to say it's a mistake, because at the time of the plea, Michigan Court Rule 6.302E2 was not in effect which requires now a trial court to advise a client if they commit misconduct, that can, between the plea and the sentence, that can affect their Cobb's agreement. So it wasn't in effect then, but at the plea taking, the judge never did advise him that if he did commit any type of misconduct between the plea and the sentence, then that would nullify or could nullify the Cobb's at the court's discretion.
Right. So he was advised at that time, and I think, thereafter, although the plea taking time is really the relevant point, that if I depart from this, you'll have the opportunity to withdraw. And
Correct, Judge. Yeah, he was not advised at the plea. He was advised thereafter at sentencing. But that was a little too late. And my client did tell the court he didn't realize that if he committed misconduct between the plea and the sentence, that could nullify the plea. I'm sorry, the Cobb's. And then I already covered the parole status issue. At the sentencing, the first sentencing, another mistake. He was promised by the court that the case that he committed between the plea and the sentence would not affect the Cobb's.
But I guess I understand what you're saying there, and that would be, to me, I guess, more salient if it happened at the time of the plea. But at this point, it seems that the plea has been taken. I understand that what you're saying in terms of the promise, but I have trouble knowing how it matters just in terms of the procedural posture in which it came up.
Two reasons, Your Honor. Number one, we also asked for specific performance, and that was denied by the trial court. I think that goes towards specific performance to have the court follow the original Cobb's. And number two, the attorney representing my client should have made some type of objection or requested or advised his client, you can ask to withdraw your plea. Number one, because there was no being advised of the fact that if he was on parole, be mandatory consecutive, which my client voiced at the sentence. He voiced at the first sentencing, I didn't know that I would have mandatory, if I was violated, that would be consecutive. He specifically asked the court that. The court never answered him, in fact. And that was on the first sentencing in the beginning of the transcript. The judge specifically didn't even answer the question. He went on to another subject. But his attorney should have stood up for him and at least requested to withdraw the plea between the plea and the sentence before it occurred, based on a defective plea, based on an unknowing plea, based on confusion, based on this promise that the subsequent case would not affect his Cobb's. That's something that did not occur as well. And I'm happy to answer any other questions. I don't know if there's anything else I can answer.
Nothing further from me.
So we'd either ask, Your Honor, to permit him to, my client to, at the very least, withdraw his plea if he chooses, or specific performance of 24 months pursuant to the Cobb's. Thank you.
Okay, thank you, counsel. All right, that matter will be submitted. And we will move on to item number 16, People v. La Follette. That's 371804. And I know I see both sides endorsed. Great.
Good morning, Your Honors. Tracy Gittleman for Mr. La Follette this morning. Your Honors, these are issues regarding offense variables, and the last issue is a Posey issue. On the first OV3, the facts to be judged to determine whether OV3 is correctly scored are controlled by McGraw. That's only the sentencing offense that my client pled to can be counted to determine whether OV3 should be scored. The trial court scored OV3 over objection from my client's trial attorney, saying that the bruise on the buttocks was the reason he scored OV3. The problem with that is, and why the trial court erred, is because the bruise on the buttocks didn't involve the sentencing offense. The bruise on the buttocks involved the factual scenario that occurred the next day on a Saturday at this campground versus the prior day, which I believe was, I'm assuming, a Friday. And the second The Saturday offense was dismissed, and he had a plea agreement where they dismissed 2 counts, and he pled to the CSC.
They dismissed 2 in
Yes.
exchange for adding a third.
Correct.
But
Correct.
counsel, there was an incident in a tire stack on one day and then an incident in a camper the next day. And I understand it seems your argument is that, well, what he pleaded to was what happened in the tire stack. But how do we know that? That's not clear to me from the record. In fact, there seems to be support in the record for it, in fact, being, the pleaded to offense occurring in the camper. So how do I know that's wrong, such that the court needs to be reversed?
Because if you look at the factual basis is particular and right on point. Only a foot fetish, having a foot fetish with an erection, which occurred on Friday. Saturday involved alleged penile penetration along with massage. So they both involve massage, but only the Friday is only foot. I believe there was back and shoulder too on Friday, but no allegation of any type of digital or penile penetration versus Saturday.
But I mean, he pleaded to certain conduct, and it's not clear to me that conduct fits any better with the tire stack incident than with the camper incident. So it's, I understand we kind of have to look at the record that we have and see if there's a reversible error in the court saying, I think this pleaded to offense belongs in this place.
Well, I would argue if the record is not clear to your honors, then it's ambiguous and it should be held and judged in favor of my client because
We're looking for a preponderance of the evidence, right?
Yes. Even with a preponderance of the evidence, if it's ambiguous and you can't point to the conduct being a certain, what he pled to, which conduct he pled to when there was 2 separate conducts specifically that do not arise out of each other, then that should be favored for my client. But I still argue that the conduct on Friday is separate, distinct, different. The conduct on Saturday had extra conduct that would have required a further factual basis to establish guilt in the plea taking. And because the conduct, the bruise and the PSI in the PSIR, actually, the victim did describe on Saturday the bruise occurring. She didn't describe a bruise occurring on Friday. She only described that this bruise occurred on Saturday. And that also involved the moving of the shorts, the attempt of penile penetration, the alleged digital penetration, totally different than Friday. And then as far as OV 11, your honors,
Same basic argument. Right?
I'm sorry?
I mean, it's the same basic argument, right?
Well, it is and it isn't. With OV 11, first of all, if your honors deny all of it, then there is no obviously resentencing as far as the OVs go, unless your honors were to grant a POSI issue. But with OV 3, that does not change the guidelines. But if OV 11 is reduced from 25 points to 0 points, it does reduce the guidelines 1 level. The argument with OV 11 is that there was no penetration. And I'm also again saying, as your honor is correct, that it's the Friday conduct, not the Saturday conduct. And that's based on the factual basis. And OV 11 does require a penetration. Massaging is not penetration. And that was the rubbing of the feet and body parts without any type of sexual penetration. And coupled with the fact that the Saturday conduct did not arise out of the Friday conduct because they were separate and distinct. One did not occur right after the other. There was at least 24 hours by the victim's own victim's own account regarding that. Can I answer any questions on OV 11?
Nothing further.
Thank you, Judge. As far as POSI, it's a difficult burden. There has to be unusual circumstances. The unusual circumstance in this case is that my client did take a polygraph and he did pass. And that was noted in the record. And that may have been one of the reasons that the prosecutor amended the information and changed the counts for my client to plead to the amended count because he passed the polygraph.
Right, and the guidelines were scored based on the offense he pleaded to.
Correct. Yes, Judge.
So,
And the guidelines scored the 45 to 85. He got 84, one less. And I know we don't look at the numbers. We look at the offense and the seriousness of the offense and the offender. And if you take all into account regarding the polygraph, the unusual circumstance of the polygraph, the fact that it was disputed as far as penetration. The sentence of the 84 months was disproportionate and unreasonable, and the extent of the sentence was disproportionate and unreasonable. The court did refer to other prior instances in Kent County. I know that the prosecutor referred in their brief to another conviction that my client has. That's a lot longer than this conviction, but that's irrelevant as far as determining whether the sentence is proportionate or not. Thank you, Your Honors.
thank you, counsel.
Good morning, Your Honors. John Donaldson on behalf of Ottawa County. I think I'll rely mostly on my brief, but I think the one thing I want to highlight is the factual basis in the plea. My understanding from reading the transcript of the PSI is that this all happened on one day. What he pled to with the other conduct that was scored as it relates to the OVs in question. And the best evidence I have of that is on page 8 of the sentencing transcript. When the courts were discussing the offense variables, the prosecutor indicated to the court that this all happened in the same time frame. And in fact says that this all happened in one event here in Ottawa County at a campground and happened in less than, I would say, 15 minutes. So according to the prosecutor at the sentencing, what he pled to.
Well, the prosecutor's arguments aren't evidence in the record.
Yeah, I know. But
I understand that's the prosecution's position. Yes.
Yeah. And, given that this was a plea, not a trial, we were kind of limited in the amount of facts we have that we can rely on. And on top of that, I would point out that the plea itself, he doesn't specifically plead to conduct that happened on Friday. I believe the plea included a date range. So he didn't specifically say I did all of this on Friday. So again, our argument is that the court found that this happened on the Saturday within the same time frame as the other conduct that was scored in the OVs. And I would rest on my brief and answer any questions that the court has.
Did you come all the way from Ottawa today?
Yes, I did.
Thank you for doing it.
Yeah.
Not sure why we have an Ottawa case.
Yeah.
In Detroit. But it's nice.
Toward the construction, I guess, right?
The SIR is the best evidence we have to determine the facts in this case. And that mimics the police report. There was no prelim to look at. There was no other evidence hearings taken. And it's obvious in the PSIR. It states that the victim said they were 24 hours apart. There's no doubt. That's in black and white in there. It's Friday, the tire swing, and then Saturday, the camper. And the victim remembered, and she was 15 years old. So she has a good idea of time. She's old enough to to understand the clock and time and remember 24 hours, she said. So it definitely did not happen on the same day. Thank you, judges.
Thank you, counsel. Okay, that matter will be submitted. And moving on to item number 17, People v. Kalina, 374407.
All right. Good morning, Your Honors. May it please the court. Tim Doman on behalf of Neil Kalina. In re-reviewing the briefs in preparation for today, I think I've said just about everything I want to say in this case. I don't know that I have much, if anything, to add by way of oral argument. So I'm content just to rest on my briefs in this case, and I would just invite whatever specific questions the court has for me.
I think I understand the position from the briefing. Thank you, counsel.
All right, thanks. I'll save my time for rebuttal.
Good morning, Your Honors. Assistant Attorney General Monica Wilson on behalf of the people. I am standing in today for Ms. Davis, who authored the brief in this matter. Just make a couple of quick points. And otherwise, I would rely on Ms. Davis's brief. I think the trial court made some pretty substantial findings as to the reason and the basis and the extent of the departure. One, it was the punishment that he talked about, the lasting impact that Mr. Kalina's actions had on his victim almost 40 some years later. every aspect of his life, his career, his military service, his marriage, everything, even 40 years later, was still affected by what happened to him when he was a young teenager. And additionally, there was a protection of society concern, which is one of the factors in that. After he was convicted of possessing cocaine, which is one of the things he's alleged and was convicted of giving to these children, he went to California, where he was from, and I think the trial court made the assumption he was probably defrocked. But in any event, he started a mission where he worked again with young teenage vulnerable boys. And even when he came back to Michigan decades later to face these charges, he's on Facebook starting a Facebook support group for young teenage boys. So I think the trial court was rightfully concerned that there was also a concern for protection of society, and that Mr. Kalina continues to seek out situations where he is in a position of trust and authority with vulnerable young boys. And so I think the trial court adequately explained the basis for the departure as well as the extent. And unless your honors had any questions, I would just rely on Ms. Davis's brief.
Thank you,
Thank you.
counsel.
I would just very briefly say that I think we were upfront in our briefing that, yes, some of the reasons for the departure may have been proper, but there was also several what we view as improper reasons mixed in. So case law is clear. If you have some good reasons, some bad reasons, you got to send it back. So in our position is that there were enough bad reasons stated by the trial court that resentencing is required. All right. Thank you, your honors.
Thank you.
Thank you, counsel. All right, that matter will be submitted. Moving on to item number 18, State of Bowen versus Beaumont Hospital, Farmington Hills, 374271.
Good morning, Your Honors. And may it please the court, Logan Francisco appearing on behalf of plaintiff in this matter. I'm going to just go over a couple of points that I believe are most important here. The circumstances today of this case, there is an error that occurred that resulted in an outright dismissal of the case. There was a path of least resistance, in quotes there, where of all the principled outcomes that the court could have taken regarding this circumstance, they chose to dismiss a harsher sanction versus an agreed upon adjournment that wouldn't have prejudiced or led to any prejudice against either party. Certainly, the law favors arguments on the merits of the case. That was unable to occur here. And plaintiff's point is that this was something that was out of the ordinary, a mistake in the e-filing system. Once it was found out about, the office, the underlying attorney did everything they could to try and resolve that by reaching out to opposing counsel, by reaching out to the court. Unfortunately, it had reached a point where the judge had already decided the motion. And then even upon the motion for reconsideration, the judge still felt that there was not an error there, that the case would not have been different or resulted in a different disposition had they heard the arguments on the merits. Plaintiff disagrees with that. The outcome would be inherently different because a dismissal based on court rule or based on a lack of response is inherently different from an actual real decision by the judge on the merits of the case, on the facts of the case.
But I think the court's point was that he was going to dismiss it anyway. Right?
Correct.
Because his merits assessment took him to the same place. Now, you can disagree with that merits assessment, but I guess I'm not sure that sort of distinction in terms of the intrinsic value is necessarily telling us a whole lot about what the court was saying.
Understood, Your Honor. And we would disagree. I think that the facts of this case with the case law at the time regarding the COVID-19 Pandemic Healthcare Act summary disposition, the Warren case in the Skipper Baines case were both available to the court at the time. There's been since the Jokinen case, which came out afterwards. But the facts of this case are completely different from Warren, and they're certainly more analogous with the Skipper Baines case. Ms. Bowen never had COVID. She didn't go in for COVID. She wasn't treated for COVID. She was just at the hospital as a result of a fall, ended up with a pressure wound.
And there was no evidence, was there, from defendants that their resources were allocated to the pandemic issues, which then caused harm to your client?
That is correct, Your Honor. And I think in Judge Cunningham referenced the Warren case specifically in his order, that would have been the reason why this case would not have resulted in a different disposition, which again, we disagree with. The facts of this case are relatively clear. The palpable error comes in where there was a lack of argument on the merits. The court had an outcome of a lesser sanction, which in this case we went over with the factors in the Dean case. Certainly the violation here that resulted in dismissal was accidental. This was not a willful thing on behalf of underlying counsel.
Well, again, when I read the court's orders, particularly together, I think he seems like he decided he was going to enforce his scheduling order and say, listen, I understand your explanation. I don't think it's enough. So I'm not taking the filing. But then he seemed to make a ruling on the merits, saying, I'm granting the motions for the reasons stated, later clarifying, PHCIA as the basis.
Yes, Your Honor.
So I don't know if the dismissal sanction necessarily is what the court was hanging its hat on.
Sure, I understand, Your Honor. And I think it sort of goes into both. But at the end of the day, we believe that this case should have been heard on the merits that the court could have and did not. And we would ask that at least we get to have that meritorious review at some point in the lower court. If you have any other questions. Thank you, Your Honor.
Time for both, counsel.
Thank you.
Good morning, judges. Alice Bell appearing on behalf of the Beaumont defendants in this matter.
And Ms. Bell, can you, maybe I'm anticipating this, but can you give me a sense of how the time plans to be allocated?
We're sharing equally, Your Honor.
Okay.
And
Everybody's getting a turn.
I will be just hitting the high points. I know this panel is very well prepared. This case was dismissed because the plaintiffs filed nothing. Okay. There was no response to the dispositive motions were filed in December, the prior year, December of 23. Dispositive motion scheduling orders were then issued by the court, two separate ones on two separate motions from two separate defendants. And those were issued immediately. They were essentially identical. That had very specific language about non-response or failure to file a response is going to mean that the court is going to assume, because these were C10 motions, the court's going to assume there's no authority for the opposing party's position and that the matters could be decided with or without oral argument. So it was very explicitly spelled out in those dispositive motion scheduling orders, and the plaintiffs just simply didn't file anything.
But I mean, that's all fine and good, right?
Mhm.
We uphold the trial court's ability to have their scheduling orders and enforce them and all that. But summary disposition still has to be appropriate, right? I mean, we can't just say, well, there was no response. And I know the shifting burdens and all that, but I think the case law says, I mean, there's one we talked about yesterday that's Judge Yates wrote recently before he left, saying it still has to be appropriate. And then we have to conduct an overall review. And we're not going to say, unless there's case law you can tell me about, that just because plaintiff didn't oppose it, you can just willy-nilly grant summary disposition, even if you look at it and think, well, defendant's wrong.
Well, respectfully, Your Honor, I would assert that the Cleveland v. Hath decision, which is published, it says that a court is entitled to enforce its scheduling orders.
Right.
And I'd like to.
And then it also says, and grant summary disposition if it's appropriate.
Agreed, but I would argue it's not appropriate here because not only did the plaintiff simply not file a response. They never even brought up the substantive underlying issue, the PHCIA, Pandemic Healthcare Immunity Act immunity. They didn't raise any substantive arguments against that in the lower court whatsoever. They did not even raise 2.612
Okay,
motion for relief from
That's
judgment.
that's not the point I'm getting to.
Okay,
My point is more practical. I'm a trial court judge. I don't get anything from plaintiff. I still have to read your summary disposition brief, don't I?
agreed, because it was
And if-
timely
and if I-
filed.
and if I read it and I think they're wrong, I still have to deny it, even if there's no response from plaintiff, don't I?
I would argue that the trial court did essentially do that because they, as
I agree.
Judge
I
Mariani
agree. But
mentioned.
I'm just talking about the procedure, right?
Mhm.
The fact that it's not, the fact that there's no opposition is, you cannot just, the trial court cannot just say, no opposition equals summary disposition as a matter of law.
Well, I would think under the circumstances with the very specific language in these dispositive motion scheduling orders, the practice and pattern of this trial court throughout ever since the COVID pandemic has been with that judge. Those are issued on every dispositive motion filed in that court.
Yeah, I'm sure.
Everyone's well aware of that. And the plaintiffs never raised any substantive argument against the underlying argument in the trial court, not even in their motion for reconsideration. They never proved prong 1 or 2 of
But counsel,
2.119.
I think it's not a default situation. This is not like on the pleadings, right? You file a motion, you have an initial burden. And then once that initial burden is carried, that's when the obligation to respond kicks in. So you filed a motion, they didn't respond. It seems incumbent on the trial court judge before granting the motion and dismissal in your client's favor to see if that initial burden has been carried in terms of the facts and the law that's been put before. And as I read the orders, it seems as though the court did purport to do that, did reach the merits, said you're entitled to summary disposition.
Understood. Yes, Your Honor, then the court did take pains in that order on reconsideration to point out that they had considered even the unauthorized reply brief that the plaintiff had filed after the court ordered responses.
Well, it's
to
not even
motion
about
for
the reply brief. It's
reconsideration.
just about the merits of your brief, right? And whether it's enough to get you judgment as a
sure.
matter of law.
Well, as a matter of law, we would say the PHCIA does apply because there was the Jokinden case does not really control here because that was decided very specifically. The panel explained in that case, they were deciding it because it was filed under a C8 standard, considering only the pleadings. This was filed under C10. We have more than the pleadings. And I'd like to add too that the plaintiff improperly attached 5 additional exhibits expanding the record on appeal for the first time.
So
Plaintiff is
we
essentially
understand the scope of the
asking-
record, right?
Right, and the plaintiff is essentially asking for a decision on the merits for the first time on appeal. And that's simply inappropriate. And I'd like to point out as well, the order from the trial court granting these motions was issued on April 2nd, 1 day before the scheduled hearing. However, the plaintiff's response brief due date had been March 13th. That was well over 2 weeks prior to that. The plaintiffs did not attempt to do anything. They didn't ask for leave to file a late response. They didn't ask for any
We
extension
understand.
until,
Yeah.
10 minutes before the order issued. So that leaves also a gap of time. That's a distinction. That's more procedurally. But on the merits itself here, we had a patient brought in, an elderly patient brought in the very beginning. This is in about 6 weeks, or not even, about 4 weeks into pandemic lockdown. And as the court, I'm sure well remembers, hospitals were in desperate straits at those times.
But we
And
know
this
from the
woman was
case law,
brought in
right?
unconscious from an unwitnessed fall at home, and she was tested for COVID.
But
On
but
admission-
Can I ask a question about this statute? These are the first ones that I've dealt with. It seems to me there's only 2 bases for, and they're broad, the statute's broad, but in order to properly invoke it, the patient either has to have COVID and you treated them for it, or the resources of the hospital have to be had been, like I said, directed elsewhere, and that's what caused you not to be able to treat this patient. There has to be some connection to, it's not just it happened during COVID and therefore you have immunity.
Agreed, Your Honor. It's-
So this person didn't have COVID, did they?
No, but they had to be tested
Okay,
because of the
so they
time
got
frame.
tested, but they didn't have it. And so is there any other evidence that that the hospital, Beaumont, redirected resources and that's what caused them to allegedly commit the malpractice that's an issue?
Well, that would go towards the general overall use of personal protective equipment. There was continuous monitoring going on because, of course, hospital acquired COVID could have been an issue as well. And in the other case law cited by plaintiff, for instance, the Skipper Gaines case, that was pandemic immunity was found to apply even though the patient didn't even get a test. He had presented himself for testing, but ended up getting turned away because, again, that was in the very early days of the pandemic when even the number of tests were limited. So here we have a patient who comes in under, sort of unknown circumstances because it was an unwitnessed fall at home. She was not conscious, I believe, when she was admitted. She got tested for COVID. It was negative, but then she was admitted.
Counsel, did anybody not get tested for COVID who came into your hospital at that time? I imagine.
I do not know the answer to that at this point, but I would argue, of course, that because of the timing, it is likely that perhaps some were not, because again, the Skipper Gaines case bears that out. Some people weren't given a test, even if they presented themselves saying, I have symptoms. So other than that, I wanted to,
I do want to let you know, counsel, if you're splitting evenly with your co-counsel, you're
yes.
just
So
about
are we at our time?
just about.
Okay, then I will leave the rest for rebuttal and allow my fellow counsel to speak.
Good morning, Your Honors. Catherine Gossick on behalf of Defendant Hartford Nursing and Rehabilitation Center. I'm going to be very short and quick. With respect to Hartford, there is evidence that there was a change in protocols due to the healthcare pandemic. Wound care was outsourced to a third party. Here, the plaintiff had a scheduled appointment with a wound care specialist from Michigan Wound Care Health and Hyperbaric Institute. Due to the pandemic that was scheduled for May 12th, and it was telehealth. Normally, that would have been something that was done in person.
From the record I see, we have the medical record from that visit. It does not look like that visit is in the complaints allegations as anything involving the malpractice. And it doesn't appear that the medical record indicates, I understand it was the pandemic telehealth. Perhaps you can just assume that, but it doesn't appear that the record that we have indicates that this, telehealth appointment happened because of the pandemic in that format.
Are you, sorry, Your Honor, just that that doesn't seem that it's because of the pandemic, the telehealth?
Yeah, I don't see anything in the record. It just says telehealth appointment and then an appointment.
Okay, yeah, Your Honor, I guess the records aren't clear, but it was a telehealth appointment due to the pandemic because of all the precautions being taken in place, and a lot of specialists weren't able to enter the building per a lot of executive orders, not allowing third parties to come into the buildings. At a minimum, I would request that this court, if they decline to affirm summary disposition, allow this to be remanded where everything can be fully briefed with the record and allow plaintiff to present their arguments substantially. Unless this court has any other questions.
Nothing further.
Thank you.
Thanks, counsel.
Good morning, Ron Letterman on behalf of Defendant Mission Point Nursing. I could tell that you are skeptical of the defense position this morning, but I want to reemphasize a couple of controlling points that I think are opposite to the predisposition that you've expressed. First of all,
Counsel, your client didn't file their own brief below. Is that right?
we filed a concurrence.
Concurring briefs in the other two.
Correct. Yes. First of all, Warren versus McLaren was the first Court of Appeals decision on the issue of COVID immunity, Judge Redford's decision. Judge Redford, in that decision, specifically rejected the argument that you had to show some sort of connection.
But counsel, there's been two published decisions since then that have held that.
That's correct. There are two published decisions which we have argued in our appeal brief are distinguishable, factually distinguishable from our situation. But Judge Redford's decision under the first out rule governs. And in his decision, he specifically says that you don't have to show that necessary resources were depleted in some sort of way by virtue of the fact that the hospital or the nursing facility was open and trying to perform the state's obligations of providing.
But do you
health.
think that, you said this, I know there's a mix, I call it Franklin, you call it Warren, but whatever it is, the decision, it's not, this is a question, not a statement. It's not as broad as the hospital treated somebody during the statutory time period and therefore you get immunity. As long as the hospital is dealing with COVID patients during the pandemic. It's not that broad. Is it?
I think that I would have to disagree with your interpretation.
So there's automatic immunity for any malpractice that occurred during that statutory time period, as long as the hospital was assisting in the fight against the virus.
Yes, under Franklin-Warren.
Okay.
That's my strong interpretation of the case. And I acknowledge that the Skipper Baines and the other decision which came after say otherwise. My argument is that those two decisions violated the first out rule. Judge Patel's heard me say this before in another
Well, I think
case.
I thought the same thing, and then I kept reading them again and again, and I got less certain that the subsequent cases were inconsistent with Franklin, and I'm not sure I've even resolved it to this day.
And I believe that case that you're referring to, Judge Redford was on that panel, right? So you've made the same argument, not just with me, but with also Judge Redford, and
He was
not prevailed.
He was, and he struggled mightily with the fact that the subsequent decisions departed from his decision. Yet I agree, he joined the majority. I think that I've got a major problem with that. Nothing I could do about it at this point. But I admit that. But nonetheless, under the first out rule, the Franklin decision is broader and applies to all subsequent cases. And I respectfully disagree with your interpretation of Franklin.
Of my interpretation of Franklin?
The one that you just announced.
Well, I think that
I
was
didn't think
actually
that was
announced in the
announced.
other two published decisions, but we understand your position, counsel.
Okay. I don't mean to be difficult then.
No, we understand.
Procedurally, however, I guess I also have to take issue with the predisposition that the trial judge, when presented with no substantive legal argument by the plaintiff, either on summary disposition or on reconsideration, followed Franklin in the similar manner that I am advocating, absent any substantive legal argument to the contrary. Had the plaintiff presented a substantive legal argument on reconsideration, maybe the situation would be different. But he didn't. He presented no subsequent argument. And I guess I take issue with the thought that the trial judge was forced to do the plaintiff's legal research and legal analysis and determine whether or not the motions for summary disposition had substantive merit.
Well, they're not supposed to. We all know that. But they also don't. Do you disagree with the notion that the trial court still has to read the summary disposition briefs and make sure that it's accurate?
He did, and he followed Warren.
Yeah, but
And
okay, but
absent, I'm sorry,
no, go ahead.
absent a substantive legal argument presented to it by the plaintiff, he interpreted Warren in a broad manner,
Right,
And he was entitled to, absent.
absolutely. And we're entitled to say that on a subsequent case, it's wrong. Right? I mean, the fact that the is unopposed by the plaintiff isn't dispositive on this, is it? Because we still have to, we have an independent de novo responsibility to review summary disposition and see if it was properly granted. And if we look at it and we say, well, you might have had an argument under Franklin, although we're not certain, but clearly under these subsequent published opinions, you don't, based on this record, then that's it, right?
I guess my response to that is that if you feel that substantively the trial court misinterpreted Franklin too broadly, that your remand to the trial court allow us to rebrief the issue under the development of the law that's occurred in the last year and a half, and with the medical records that exist, and determine substantively whether the defendants are entitled to COVID immunity. There were no such medical records that were presented to the trial court. And I think that it would be improper for this court to resolve the case substantively, or the issue substantively, without allowing us to fully brief the issue and have the trial court reconsider it or rehear it with the medical records.
The facts haven't changed, right? Only the law has, arguably.
That's correct.
So it's a denotable review of the law. If like, why would there be additional factual development?
It would be because we would produce all the medical records to complete the record, the factual record, which doesn't exist at this point. Our substantive legal arguments were premised upon Franklin and our interpretation of Franklin, which is different than seemingly your interpretation of Franklin. If you disagree with our interpretation of Franklin, then let us go back, let us submit all the medical records that were not yet part of the record at the trial court, and have the trial court reconsider the motion consistent with your legal directives. That's my response. Any other questions, please?
Nope. Okay, thank you, counsel.
Just briefly, Your Honors, I wanted to touch on a couple things. First, is the lack of substantive argument in our motion for reconsideration. Of course, we were unable to make any substantive argument prior to that motion for reconsideration, as the court did not hear the motion on the merits and did not provide us an extended time to submit a response. In the motion for reconsideration, our whole purpose of that motion was to have the court reconsider its decision not to hear the case on the merits, not on the merits of the case itself. So, you know, our argument was that the error occurred when against what we believe was a path that promotes the interests of justice while also not prejudicing either party. The court could have adjourned the motion with the agreeance of defense counsel, and we could have heard it. And then as far as the substantive law, Skipper Baines was also available at this time that this decision was made. And the judge decided upon his own volition to include that section regarding Warren in his order, saying that he was relying on Warren. The Skipper Baines case is also available, and that also said that there needed to be a causal connection between the care being provided and the COVID-19 pandemic, and that's not existent here. As I've said, this patient never had COVID, whether they were tested, doesn't matter. They didn't have COVID, they didn't have COVID treatment, and they didn't get COVID in the admissions to these facilities. So that's the couple points I want to hit on. Any other questions from the panel?
No, nothing further.
Thank you, Your Honors.
I guess I should ask, does anyone on this side have any brief rebuttal that they would like to do? I think everybody maybe has a little bit of time, but it's not an obligation.
Understood. Just extremely briefly, Your Honor, on the procedural side, I wanted to point out the unpublished decision we cited in our brief, Green v. Detroit Square Properties, was on even arguably a little more sympathetic facts, the Court of Appeals decided that this computer function as the only allegation of palpable error, some sort of computer malfunction with filing of a response to a dispositive motion was not adequate to meet the standard for 2.119. And on the merits again, I would agree with Judge Murray that Warren or Franklin versus McLaren Flint does not stand for blanket immunity, just simply it happened during this time period. Because the later case law does say there has to be some connection. But the Jokinen case, there was absolutely no connection whatsoever. There was no, and obviously it was decided on the pleadings only, so they didn't have any factual support for it. Here, essentially the same thing, because plaintiff never submitted any factual or substantive response, but also we do have a COVID test that occurred at Beaumont Hospital during her admission. So that the Warren case specifically says there just needs to be some connection, which is what the clarifying decisions have dealt with. And we would argue that this is, especially based on the timing, the testing for COVID and needing to rule it out was enough of a connection for immunity to apply.
Thank you, counsel. All set? Okay, thank you. That matter will be submitted, counsel. Thank you. Okay, moving on to item number 19, GCXH v. Munson Healthcare, 373-603.
May it please the court, Holly Wender on behalf of plaintiff appellant. This is our appeal of right on leave granted, seeking reversal of the trial court's grant of Munson's motion for partial summary disposition as to claims of vicarious liability for Dr. Cato based on ostensible agency. The motion was filed while the Markle case was winding its way through the appellate courts. This case falls in, our position is this case falls squarely within the confines of Grew and Markle. Plaintiffs came into the hospital through the emergency department to seek care for their gravely ill child. Dr. Cato is the doctor who read the initial CT scan. The allegation is that she didn't correctly read it or didn't correctly report the findings. But regardless of the factual dispute, the factual questions here, for purposes of the issue before this court, the record supports that there was minimally a question of fact as to ostensible agency. Again, plaintiffs brought their child to Munson's emergency department for medical care. The plaintiff mother submitted an affidavit attesting that she believed the individual who read the CT scan was an agent of Munson. The affidavit does not conflict with any deposition testimony, as there were no questions on that issue at all. There's nothing that the hospital did to dispel her reasonable belief, and there's no negligence on the part of the plaintiff. So the Grew factors have been met, and under the clear guidelines of the Michigan Supreme Court's order in Markle, the trial court should be reversed. I think it's a pretty straightforward case. If you have any questions, I'll just.
Not for me.
You have time for rebuttal?
You have time for rebuttal. Thank you, counsel.
Good morning. Adam Pradke on behalf of Munson. We tend to agree it's a pretty straightforward case. What's critical is that ostensible agency is proven through elements. It's not a multi-factor test. The first element requires that the plaintiff had dealt with the purported agent. The plaintiff can't prove that Dr. Cato had ever dealt with the plaintiff here. They admit as much in their brief.
Can I ask a question about this?
course.
Because when I first picked this up, I thought, there's no way that I would think Munson would win. But then I thought about it, read the cases and thought about it. And, what does it mean to deal with somebody? What if a patient came in unconscious in a stretcher, never met the surgeon does the operation and is done and maybe meets her afterwards or something. I mean, it's the same thing as this woman was out in California in her apartment or something, reading something. The fact that you don't meet them, is that really dispositive?
So I think, I believe it was Myers that was before the Supreme Court as a decision of this court that was
denied leave in the Supreme Court. And there they basically said that, like, you're supposed to do something after they wake up, essentially. I think,
Yeah, is that published or unpublished? You remember the Meyer, you said?
I apologize, I don't remember it.
Okay, I'll look it up.
Yeah, it wasn't particularly applicable here. But I think for the purposes of this case, I don't know that it'd be true everywhere, but the assumption, I think, between the parties is that the applicable person is the mother who actually was speaking with the doctors, things like that. I think it's in maybe Markle 4 where they explain that it's basically the first party is the hospital, the second party is the physician, third party is the relevant person. So I don't think there's too much dispute over that. And in terms of the merits of it, I think dealt with has to mean something. The Supreme Court didn't say the person treated by. The language is pretty specific. And
Well, if it said that, you'd probably be making the same argument, wouldn't you? I mean, I feel like we're trying to spin a limitation out of a descriptive phrase. You go to the hospital and it seems like Markle's rule is you go to the hospital, you get admitted to their ER for care. The presumption seems to be, unless there's some pre-existing relationship, that the care you're receiving there is being provided by the hospital. Unless there's a pre-existing relationship or unless there's something affirmatively done to dispel that with respect to the physician at issue. So it seems like we're taking this phrase dealing with and building a restriction out of what seems to be just a way to describe going into a hospital and getting care.
I think, one of the things about the way the law in this area works is that it's basically, we're looking at this perspective of your third party here. It's what did they think?
I think most people go to the hospital and they don't know about all the different contracts and subcontracts and what have you. And that's not really their concern. They're there for, particularly with an ER, for emergent care from the people who are there to be staffed. So it seems like from their perspective, that doesn't really help you.
I think, of course, this is an exception to the general rule about subcontractors. I think looking at the first elements, it's, leaving aside for now dealt with, you have your actual belief under the subjective standard and you have your reasonable belief. I don't think it's particularly problematic for the court to add another requirement that they had to have actually met the position that they're talking about in terms of the ostensible agency.
Doesn't that end up immunizing broad swaths of care that are provided by a hospital? There's all sorts of people who provide care at a hospital in connection with a patient who that patient never meets. So, it seems like you're narrowing the window of potential liability. And I understand why the hospital may be interested in that, but I don't know how that makes sense.
Well, again, it is an exception. And, certainly in this case, we're dealing with the purported agency of Dr. Cato. She's the defendant. Her employer is the defendant. The fact, whether they can, extend vicarious liability on Munson, I think, I don't think it should be assumed because of the fact that this is an exception. It might seem a little awkward, this aspect of dealt with, but I don't think it's particularly, it's not without sense that you would just say that this doesn't apply to someone they haven't met. They're creating a class of people who can be subject to vicarious liability. And, again, the Supreme Court didn't say they put it in. They didn't say the person treated by these specific language. They've dealt with 2 ostensible agency cases in the last few years, which they hadn't done for a long time, and they didn't change the test. When you look at GRU from, I think it was 1978, this is a case where a guy has a dislocated shoulder. He's laying in a hospital room for the better part of the day. A random doctor walks in, literally puts his foot in his chest and yanks on his arm. And, the point there was that how would the patient have any idea that this guy with his foot on his chest is not an employee? I think it's kind of a far cry from the situation here where you're talking about someone who is sort of behind the curtain.
But from the patient's perspective, why do they care whether it's somebody who has their foot on their chest or somebody who's making a, critical treatment decision with respect to their brain CT? I mean, both are very consequential for the care. So from their perspective, why does it matter whether, that person is in the room with them when they're doing it or somewhere else in the hospital? Or in this case, from their, home in San Francisco because technology allows.
Right. I would say it's not really our job as litigants to try to decipher why the Supreme Court has chosen to do it this way. Perhaps, we certainly have a lot of disagreements about how the Markle decisions turned out. We don't think a lot of it makes sense. The Supreme Court is another ostensible agency case that they're hearing in the next few months. Perhaps they'll clarify further. But at this point, we can only argue to apply the law as it's written. And, we think that dealt with has to mean something. And to us, that means that there was an interaction between this third party and the physician who's subject to vicarious liability.
Understood. Any further questions?
No.
No,
thank
not for
you.
me. Thank you, counsel.
I think you phrased it correctly, Judge Mariani, when you said dealt with, it was used as a descriptive phrase. I tried to articulate that. I don't think I articulated that as clearly. But further, I don't believe.
Well, I mean, descriptive phrase, but they set it forth as like a 3 or 4 prong test to determine ostensible agency. We're supposed to apply what they say, right? Not just saying it doesn't really mean much. I mean, it's the test that they told us to apply.
Perhaps, but yes. However, I don't believe, and maybe I'm wrong, but in the Markle order, when they restate the GRU order, I don't know that they use I'm talking about the Supreme Court,
Yeah.
2025. I didn't see the dealt with language in their
In
reiteration.
their order, but it's in all their opinions. So which one are we going to look to, the opinion or the order?
The order the order reaffirms GRU, which essentially made the distinction between a patient appearing at a hospital for seeking care from the hospital versus being in the hospital just happened to be the situs of the location where the physician that they worked with was working out of. That was essentially the holding in GRU. Markle then took it a step further and clarified that if you're seeking care you come in through the emergency room, it is reasonable to assume that the people you're getting care from are agents of the hospital. And I think that is simply the rule. And I think by focusing on dealt with, we're creating yet a fourth element that doesn't exist. Was it reasonable? Was it reasonable for the patient to assume that the people dealt with, the people that were providing care, the people that they were, it doesn't require that there be a face-to-face interface. Otherwise, that would say that anytime a pathologist misdiagnoses cancer, the hospital's off the hook because you never see the pathologists and often don't interact with radiologists. It's very common for them to be somewhere else. The focus again is on the reasonableness of the patient, in this case, the mother, because the child or the baby. The mother's belief that she went there to seek care because her kid was sick. I mean, and they needed to be in a hospital. So, and I just wanted to also point out that in addition to, I think it's Webb that's on appeal right now. There was oral argument recently on that. It's an ostensible agency case in front of the Supreme Court. In her dissent in the denial of leave in the Grivash case, which let me see if I can find the Justice Holden noted that she's questioning whether or not the ostensible agency, the breadth, I should say it this way, whether the breadth of the ostensible agency issue should be reconsidered in light of medical malpractice cases altogether. I think the tension is that we're taking sort of a corporate premise and applying it to medical care. And I think that's where the tension comes in. So I just wanted to bring that case, Grivash, GRZY it's 513 Mish 982. It was Supreme Court docket number 165968. And the Webb case, Webb versus Hillsdale, is docket number 167955. And I apologize, I don't know if oral argument was held yet, but there is a MOA, I think, that was ordered in that case. You have any other questions?
No, nothing further from.
Thank you.
Great. Thank you, counsel. Thank you both. Okay, that matter will be submitted. Okay, we'll call item 20. This is two consolidated cases. Estate of Thomas v. Heartland of Canton, Michigan. And that's case numbers 371166, 374483.
Good morning, Your Honors.
And how are we doing these two? Would you
How
like
the-
to argue one appeal and then argue the other appeal? You take turns that way, or how would you like to go about it?
Seeing as they're two very different topics.
Okay, so, but it's still the net amount of time is still one. We understand how they interact. Yeah, okay. Okay, go ahead, counsel.
Good morning, Your Honors. Catherine Gossick on behalf of the defendant. This first appeal involves the request for various confidential financial documents. It includes tax returns, balance sheets, monthly and quarterly income statements, as well as staffing budgets, payroll, and CMS cost reports that include settlement data. On top of that, there's also any governmental citations that the facility has received spanning over several years involving non-party patients. This is a typical medical malpractice action. It involves alleged improper wound care treatment for a span of a couple months. Medical malpractice, it's what is the applicable standard of the care, breach thereof, causation, damages. Here, I, to this day, don't understand how the financial records go to whether or not the nurses breached the standard of care, and whether or not the facility did or did not properly staff the correct ratios. There are minimum ratios done by CMS. There's testimony from the administrator regarding numbers as to how many nurses were on staff on those admissions can be provided and is available, but any of the financial record goes to motive. It doesn't matter whether the facility had enough money to pay additional nurses or didn't have money. The question is whether or not they properly staffed the facility. And unless this court has any questions, the only other thing I want to add with citations is the physician-patient privilege. That is not a privilege we can waive to produce documents that involve non-party patient information.
Is there a way to redact the documents to preserve the privilege, but still produce the documents with relevance?
So the problem is the Johnson case says, even redacted names is not sufficient. There, the operative log couldn't be produced because there's any information. So it would have to be.
Hey, this isn't an operative log, though. I mean, this is a citation that's issued by a regulatory agency. So presumably there's some information on it that is not privileged.
Yes, majority is because it all involves care of non-party patients. And it says the incidents that occurred with the non-party patients. And plaintiff does admit they can get unredacted versions through FOIA.
Can they?
Yes, Your Honor.
So explain that to me. If there's a physician-patient privilege here, it's only that patient's to waive. And it seems like there's some case law that has said, just because it's with a third party doesn't mean that that third party can produce it. I understand your obligation. So I guess how can they go about getting it through FOIA?
That, Your Honor, is what I also don't understand. 'Cause I know the Meyer case involved third-party data from the government of non-party patients, and they plaintiff received it from another source, and they were told to give it back, and they cannot use it in that case. So
Yeah, they got it from what's now in DHHS.
Yes.
So
Again, even if plaintiff were to get it through FOIA, it is our position, it's not admissible in any way, shape, or form. It's not relevant. It involves non-party care. So if they want to look at it and see it, that's a whole different story about admissibility, but we have a privilege we cannot waive, so we cannot produce it.
well, you can't produce anything that's privileged, at least.
Correct.
But I guess my question is, I understand we're talking about a very redacted document.
Yes.
But
And-
there's still a document that you could
And
produce.
I would argue that that's not proportional to the needs of the case
Okay.
here.
But that's a proportionality, discoverability sort of issue, not a
Yes.
privilege issue.
Yes, Your Honor.
Okay.
So unless this court has any other questions on the discovery issue? No. Thank you.
Thank you, Counsel.
Morning, Your Honors. I'm Brian Sheffman. I represent the Thomas Estate. In this case, counsel has referred that the staffing is known, and that may be true that we know the staffing. However, the federal law is very clear. It is the census of the patient population and an assessment of the acuity of the patient population that dictates the type and kind of staffing, the frequency, the volume of staffing that is required. We took the deposition, and I refer to this quote from the deposition of the senior executive officer of Heartland. And she testifies that basically she was presented with a budget, and there is no indication that the census and acuity of the patient population was taken into consideration at all. So the documents are important for two reasons. You will have, on the one hand, the financial documents, which go to the whether or not they properly considered federal law and the census and acuity of the patients. And then
How do the financial documents tell you that?
well, it would tell us that there was an absence of all other documents. It's not just, there's a broad category of financial documents that we've asked for. And so either the considerations relative to the census and acuity are taken into consideration or they are not. So we have to at least have some discovery to determine what was taken into consideration, because by the testimony of this senior officer, nothing was taken into consideration by the parent operating company. A budget was simply funded. And perhaps we may presume that it was funded on a blank percentage increase from the prior year or a percentage reduction from the prior year. We don't know what it was funded upon. And so we're trying to conduct a discovery to see if they've complied with federal law. The other goes to the citations that were issued. I think we are entitled to see whether or not, and the issue really is, what did they know and when did they know it? Because if we're going to allege gross negligence and make a claim for gross negligence, seems to me we ought to be able to prove with some evidence that they knew or should have known that they either were not complying with federal law in creating a financial program for staffing based on census and acuity, and or they should have taken action on past citations for similar issues. Were they turning the patients? How many ulceration cases like this did they have? How many malnutrition cases did they have? How many cases where there was dehydration? we have all of those elements in the Thomas case where this individual was basically just left in a holding tank. She lost 75 pounds in the first 60 days. She was so malnourished, she didn't have a prayer of recovery.
So I understand your case. But then, what of the care for other patients? I mean, what does it matter if they have 0 citations or 100 in terms of your client and the care
It goes
that,
to the issue of what they knew and what they should have done about it. So if
well, those obligations presumably would attach even if, I presume it's not your position that just because they haven't been cited for this before, they're off the hook.
No, not at all. I view, and this is where we get into the gross negligence consideration. What do we have to, should you just as a lawyer make a gross negligence blanket allegation before you get into the facts of the case? Or should you do your discovery and then make a motion to amend to say gross negligence? Because the facts of the case aren't changing. The standard of what they have done, whether it's negligence or gross negligence, that may be indicated by different sets of facts. So it seems to me that I've got 2 ways to prove gross negligence. Either a jury is looking at these injuries and the lack of care as grotesque, as being grossly inappropriate with a lack of concern, or I can demonstrate it by showing this is an institution that doesn't follow federal law governing the staffing and the care of its patients based on census and acuity.
You wouldn't have another X issue there? I know as your position is for admissibility, what have it?
Sorry.
In terms of how do you get that evidence in?
Oh, the evidence of the factual issues relating to her care?
Others.
Oh, the others. You're talking about citations that would redact the name.
Right. But in terms of just, you want to use how
how the institution is aware of and took no action to correct. So how many
with
times?
respect to other patients?
Yes, with respect to other patients. And that is relevant because it shows knowledge, scienter. It shows a lack of concern for the patient base. So it seems to me that there are 2 ways to show the elements of gross negligence, either on the specifics of this case, that their care was so abysmal that it shows a lack of concern, or I can literally show that from an administrative point of view, there was a lack of concern based upon their failure to develop the financial programs in accordance with federal law and their failure to take corrective actions given the number of citations for similar situated people.
And how do you get past the privilege issue with respect to those citations?
There won't be any patient names in there.
Well, it doesn't sound like names is necessarily it. I think we have some case law that suggests, well, just because you take the names out, maybe that's not enough because there's still documentation of the care that they received. So how do you get that information? I guess, do you have any authority that's dealt with this issue?
I do not.
I didn't see any.
What I do know is the way the state issues the forms. There are citation blurbs that are assigned, and the specific factual elements as to whether or not this patient was turned properly, whether they were all of the personal information can be kept out. But I mean, we can have an in-camera inspection as to what is privileged and what should remain privileged and what should be allowed to be seen. But the fact that they have been cited before for this, and I don't know if they have or not, but the fact that they might have been cited for it, it seems to me goes to what they knew, that they should have taken some action. I think that's about all I have to say on this aspect of the appeal. Unless you have any other questions.
No, thank you. Thanks, Council.
I just want to make two rebuttal points before moving on to the next case. With respect to the financial records, the deposition that plaintiff counsel attached, Renee Hamilton, that wasn't attached below. But regardless, in that deposition, she does talk about how staffing is determined, patients per day, and the director of nursing discusses with her acuity of different patients, and that's how the number of nursing staff comes to be. Again, why there was or was not proper amount of nursing staff is irrelevant. The question is whether or not there was proper nursing staff. And the first thing that has to be determined is whether or not there was a breach of standard of care with the nursing staff. Was the plaintiff not turned every 2 hours? Was the patient not seen before you even get to the staffing issue? And with respect to the citations, there is a plethora of cases talking about prior lawsuits and prior bad outcomes. Just because something happened with another patient by another treater, again, you're looking at different nurses. Just because one nurse with one patient 6 months ago may have done something, doesn't mean that can be imputed to another nurse who did something 6 months later with regards to this plaintiff. Case on that is pretty clear. And unless this court has any questions, I can move on to the next appeal.
I don't think so, but I think we'll be flipping, right? No, that there, I think for purposes of that appeal, you've had your opportunity, and we'll move on to your appeal now.
I could switch desks.
Yeah, just physically move them. Yeah.
You know, the COVID immunity statute seems to be the opposite of there's nothing new under the sun. There's always some permutation of the factual developments that either weave in or weave out. Clearly, the early cases all seem to point toward there being some connection between a COVID diagnosis and treatment, or at least presenting at the hospital for COVID testing, where that one individual was beaten by a security guard. But clearly, what is the purpose of the admission was the first series of considerations. And then was there a nexus, some kind of connection between the care? And I think that goes back to the statute itself. It has to be an injury sustained by reason of those services. So in this case, we have a long hospital, stay at Heartland for almost 45 days, where COVID is not an issue. She is admitted to the hospital because the infection becomes so bad that she becomes delirious, and they put her into the hospital. She comes back from the hospital. She's there at Heartland for a few more days, and then and only then is there a COVID diagnosis. When is that? Do you have the date of that? Is it April 15th or sometime around there?
I believe,
Yeah.
so she's in Heartland from February 22nd until the 3rd of March, or the 8th of March, 15 days. And there is a closed healing wound that is diagnosed. Then from 3/8 to 3/12, she's in St. Mary's Mercy Hospital. And that is related not to COVID, no COVID related care, and it's not even during the COVID period of immunity. But the purpose there, as Brian Judge relates in his affidavit, Dr. Judge related in his affidavit, to the beginnings of an infectious process related to these ulcers. So then she is readmitted to Heartland on 3/12 and stays until 4/15. It's unclear whether it's the 15th or the 16th of April. And then COVID is suspected on the 15th or the 16th, and she's admitted to St. Mary's Hospital on the 17th. From there, she stays until the 27th of April, and then back to Heartland. So all of the period of inpatient COVID-related care occurs well after the appearance of the ulcerations. So there is no nexus whatsoever between any aspect of COVID care and the appearance and the degeneration of these ulcerations.
But there is a connection between her being in Heartland and having COVID and being treated and monitored for it, correct?
For the 11 days after that hospitalization. So Heartland cannot,
Around April 15th or 16th, right? And then we just said,
yes, that's correct.
right, from then until sometime, which when I was looking, I thought it was around June 20th or 21st.
No,
There was, she either had COVID or they were monitoring her for it. Is that not accurate?
no, she's readmitted to Heartland from April 12 to 4/15. On 4/15 or the 16th, she's transferred for COVID. She's held inpatient at St. Mary's until the 27th of April. So from 4/17 to 4/27, that's COVID care in the hospital. Heartland can't get immunity for that care because the damages that they had already caused still existed. And then she's readmitted at Heartland, where she stays from 4/27 until May 9th, 5/9/2020. So she's got at most between 11 and 13 days of COVID monitoring. Her COVID care had ended at the hospital. So at most there's 11 days that could be argued. Now, the recent cases, including the Alley case, which is unpublished, but the other published cases still speak to the language of the statute that the care, the COVID care must be related to the injury. Here, we have no relationship. The unrebutted affidavit of Dr. Judge is that at no time was the COVID care of those 11 days contributory to any aspect of her illness. This is not, when she's at Heartland again in those 11 days, she's not on a ventilator, isolated on her backside where they can't turn her. She is just being monitored. COVID testing had already been negative. So she's just being monitored. And they could have been turning her. They could have had wound specialists. There's all a host of things that they could have done. But the judge affidavit makes very clear that there's no relationship between any aspect of any COVID care to the appearance, which is prior to COVID, or the exacerbation of these ulcers.
But you're saying it would be different if she entered Heartland without the ulcers and had COVID, and then they were dealing with her COVID and she developed them during that time.
Yeah, absolutely.
Okay.
You know, here, this is more to the cases that said immunity does not apply, simply because this person didn't seek out COVID care, was admitted, she had a fall, there was some kidney issues, renal insufficiency issues, and she's there for nearly 2 months before there's a COVID issue. In fact, part of the time of the admission is before the COVID period even applies. So it seems to me that
Here's what, and I don't know what to do. This is what Franklin says. Plaintiff does not dispute that he had COVID-19, but contends that the fact that he contracted COVID does not automatically render all subsequent care he received covered by the statute. This argument does not comport with the statutory language. But then they do say plaintiff alleged that he developed multiple pressure ulcers while in defendant's care. Those injuries were a consequence of the care, which would distinguish it if your client had the ulcers beforehand.
The timing is critical here, because unlike, I don't personally know whether it's Warren or Franklin.
I could tell you, it is Franklin. Originally, it was our fault. We originally captioned it wrong. We flipped his first name and his last name, but we fixed it since, so it's Franklin.
Okay. So unlike that case, all of the injuries came well before the COVID diagnosis. And as Dr. Judge says in his affidavit, the course at that point, by the time she had COVID, her course was set. She already was she was admitted to St. Mary's for the first time, almost with fulminating septicemia. So this is a woman whose care prior to and well after the COVID diagnosis deals with malnutrition, dehydration, the loss of a massive amount of weight, the appearance of stage 3 and 4 ulcers. So it seems to me that that is enough. And then the other issues are the issues of gross negligence. And when do we bring these issues up? Now I did attempt to bring these issues up at a point in time when the defendant pulled the trigger on the immunity statute. Meanwhile, denying my access to all of these other records, which would have gone to gross negligence. It seems to me that the absence of 2 words in a complaint, that being gross negligence, is not necessarily dispositive of whether or not I should be prevented from bringing to the jury the fact that the care here was of such low quality that a jury is free to determine it was gross negligence.
But you're the master of the complaint, right? Did you ever move to amend the complaint to add gross negligence?
I did move to amend the complaint.
Okay.
And it was denied. That's part of the appeal that I filed. So
And when did you move to amend?
discovery was still open. This motion for the production of the financials and the citations was still pending. I don't believe we had gotten very far in the deposition process at all, as I recall. I just wasn't going to allege gross negligence until I got to the depths of the nature of what was going on in this case. Once I did, it was right about the time they brought their motion to dismiss based on the COVID initiative. I moved to amend and that was denied. I think it was unreasonably denied.
What was the trial court's rationale? If you could, I'm trying to find the order.
Sorry, Your Honor.
What was the trial court's rationale for denying the motion?
Fortunately, the trial court denied the motion orally, but never issued its order.
Yeah, so it was not appeal. There was nothing to appeal then.
Technically, no.
I didn't think of it. I don't remember seeing it.
Yeah, I didn't see it, so I apologize for that.
But even leaving aside the issue of the financial documents and the citations, clearly there are facts sufficient, I think, for gross negligence. And
Counsel, I'm just gonna warn you, just for purposes of this appeal, you're running out of time. So if you want to save any for rebuttal.
okay.
I think it's very clear that the case law now says there has to be some connection, not just with COVID, but the COVID has to be connected to the nature of these injuries. And here the injuries preceded COVID. So I think that the case law, this case is consistent with all of the cases. The Thomas case is consistent with the non-immunity side of the line. COVID was not the purpose of the admission. The ulcers and the injury appeared well before COVID, nearly 60 days. They did not form during or as a result of COVID-related care. They became unmanageable well after, before and after COVID. So COVID didn't play a role in even exacerbating the issues. And the COVID-related treatment here was provided by another institution, which they should not be allowed to claim any immunity for. And even if, I did concede that at most there could be 11 days, 11 to 13 days at question. But here, there is still no relationship between the 11 to 13 days of care after discharge from COVID while she was in Heartland to any of the injuries. And Dr. Judge's affidavit is unrebutted. That's all I've got.
Thank you, counsel.
Your Honors, I would like to address the gross negligence issue. As briefed in our brief, that issue is not preserved. There was no order entered in that case, and the leave granted in this case was limited to the COVID-19 immunity issue. Aside from that, there's well-established case law that you must plead in avoidance of immunity. Our affirmative defenses had COVID immunity. Our initial disclosures also raised it. The motion for summary disposition was filed in February 2024. Plaintiff did not even file their motion to amend the complaint to add gross negligence until October 2024. There is undue delay here. And again, there is no evidence to support any allegation of gross negligence. The financial records, again, have nothing to do with whether or not there was a breach in standard of care and whether that breach amounts to gross negligence. With respect to COVID immunity, this case is exactly like the Franklin case. I do want to clarify that the trial court did not grant summary disposition in full. It was from March 29th until her discharge on June 21st. So there are remaining claims from February and March in this case, which is why it was an application for leave to appeal. In this case, on April 1st, the decedent's caretaker guardians were contacted, were told about all the COVID protocols being in place. Several weeks later, on about April 15th, the decedent started having COVID-19 symptoms, ended up testing positive for COVID, and for a long time after that, struggled with issues related to COVID. She got pneumonia from COVID, a kidney injury from COVID, and throughout all the admissions going back and forth between the hospital, at all times, she was in droplet isolation, even when she was no longer testing positive for COVID because she was still experiencing COVID symptoms. This is similar to the case that's unpublished. Judge Mariani, you were on that panel, the Holmes v. Riverview case, where it involved the heating pads with the physical therapy. The plaintiff in that case did not have COVID-19 anymore, but was still being treated for residual symptoms of COVID-19. Here, the decedent was still being treated for residual symptoms involving her respiratory issues and kidney issues. And again, was in droplet isolation until her final discharge on June 21st.
What about, it sounds like counsel's distinction is just is an ordering point here that, what brought her to the hospital and what required care and what gave rise to the allegations were non-COVID related conditions. And the fact that she, may have contracted COVID subsequently isn't, enough to entitle you to immunity as a matter of law, just because that connection isn't sufficient, I suppose. So why is that wrong?
Your Honor, I don't see a distinction between whether or not had she come in with pressure ulcers or not. I don't think that makes a difference. The fact that plaintiff is alleging that they got worse during this period of time where she was being treated for COVID-related symptoms, the statute applies. Again, if Franklin would have been, or Franklin had pre-existing pressure ulcers, how does that really make a difference in that case? If there were pre-existing ulcers, the issue is whether they got worse, and was that in some way connected to COVID-19? And in this case, she was being treated for COVID. There's that connection, droplet isolation, extra PPE. That's all been established. There's no difference for not having, which actually here plaintiff did allege that new pressure ulcers did develop. So in that case, I wouldn't see a distinction either.
Okay.
And I do want to mention that, again, Franklin says that COVID immunity is not narrowly applied just to COVID treatment. So here, the respiratory issues, immunity is not just related to that. There's been time and time again, Harris, Monroe, these are all pressure ulcer cases where the plaintiffs have alleged either new existing pressure ulcers or worsening ones that are related to COVID. There's no distinction here from any of those cases. Unless this court has any questions?
Further? We've got about a minute, counsel.
As to the timing and undue delay, Your Honor, Judge Lillard had an extended period off. We, as most lawyers do, we wait until we get the notice of when the briefs are due before we docket our time and make arrangements. Because of the time that she was off, as I recall, we did not get a docketing sheet advising that a earlier brief and response was due, which is why our motion, which was filed along with our response, was not done. The case was taken over after a very long time by Judge Sullivan. Judge Sullivan, as I recall, took an inordinate amount of time to make his decisions. But I just want to point out, I can't remember how many months Judge Lillard was off, but I know that there was considerable delay. Secondly, part of the delay was of the defendant's own making in refusing to turn over the discovery that we had been requesting. I want to make just two other points.
Quickly, counsel, because you are out of time. So if you can wrap it up very quickly.
The statement of continuing injury from these pressure ulcers has no relationship and no effect from COVID. Dr. Judge's affidavit is unrebutted. He states in his affidavit, COVID had nothing to do with her injuries. Therefore, there is no treatment related in that 11 to 13 day period or anytime after the discharge from St. Mary's. There's no COVID treatment that could have caused or related to the injuries or the exacerbation of those injuries. That's all I'll say.
Okay.
Thank you.
Thank you, counsel. Thank you both. Those matters will be submitted. That brings us to the end of our 10 a.m. case call. We'll take a brief recess, about 5 minutes. Okay, good morning. Still have a few minutes of it left. We are ready to begin our 11 a.m. session for the day. I will not repeat everything I said at the outset this morning, but just a reminder that if your case involves minors or protected or vulnerable individuals, please don't use those individuals' names on the record since this is being recorded and will be publicly available. Instead, please use initials or other non-personally identifying information. Okay, with that said, We are at item number 21. El Turk v. El Turk, 373-634. I believe we have one party appearing remotely, and we have appellant here today.
Good morning, Your Honors.
Before we start, can I just check? Do we have? Okay, great, perfect. Thank you.
Good to go?
Good to go.
Roy Snelly, appearing on behalf of the plaintiff, Dr. Roy Elturk, plaintiff appellant. I would like to touch on several issues raised in the brief while doing my best not to just regurgitate the arguments I made in my.
Yes, we are very familiar. So.
My very long brief, which I apologize for. I would like to, and of course, please jump in at any time. I always find that your questions are probably more relevant to you than me just talking at you. But I'd like to start with the issue of awarding statutory interest. As you know, the trial court ordered that the estate, for lack of a better term, be divided 60-40. 60% awarded to the defendant appellee and 40% awarded to the appellant. The courts ordered, and I quote, plaintiff shall make equal payments over 10 years, subsequently got changed to 15 years, and the parties shall include in the total amount the statutory interest. Now, statutory interest doesn't apply to divorce judgments. If she was referencing, because the trial court did not mention which statute that she was referring to. So I looked at the statutory interest that usually applies to civil judgments, which is MCL 600.6013. And the court in Lawrence v. Lawrence did hold that particular statute 600.6013 applies to civil money judgments, not divorce judgments. So I was tasked with drafting the judgment of divorce, and the only other statute that I could guess that she was referring to was MCL 438.31 legal interest statute, which holds like 4 or 5% shall apply to judgments. Regardless of whatever statute that the judge meant to reference there, statutory interest is not applicable in a judgment of divorce. So awarding 5% interest, which provides the defendant appellee with a windfall, it's in addition, it's over $500,000 that she would receive in interest over the course of the repayment of 15 years. It doesn't feel very equitable to me, but the court didn't tell us why it believed that that was appropriate. So we don't really have much to talk about.
Tough for us to review.
Yes.
Understood.
Yes, and I know normally what happens is you send it back to the court and you say, tell us why you came to this number. I would argue that this particular issue doesn't need a remand, because one thing we do know is the judge referred specifically to statutory interest. And the previous case law provides clearly that statutory interest does not apply in judgments of divorce. And that being true, the court did not have the legal authority to order statutory interest on the property award. So we would ask that this court just overturn that particular ruling as it relates to the statutory interest applied to the property award. The second issue that I'd like to touch on is the issue of fault that the court found. Both parties were arguing for more of the marital pie, if you will, based on some alleged bad actions of the other party. The defendant appellee's argument revolved around an alleged extramarital affair that Dr. Elturk had with a woman that he worked with that allegedly occurred in September of 2022. And as I tried to brief thoroughly, cited to the transcripts, the defendant did not find out. Well, the affair didn't happen until August of 2022, according to my client. From what he could remember is around August. The defendant found out in September. In July, so months prior, the defendant asked for the third time for a divorce. She moved out of the marital bedroom. She never returned. She said, that's it. It's over. Done. Beyond that, my client provided testimony that the marriage was over for him long before that. He argued that the way that defendant treated the children, the way that she talked to him, the way that she talked to him, the plaintiff, had caused the breakdown in the marriage years before. So I filed a motion in limine to eliminate, any evidence of that to be used as fault, as I found case law out there that said if you learn of a subsequent affair after the breakdown of a marriage, you obviously can't argue that that caused the breakdown of the marriage. If your marriage is broken down and then, somebody has an affair later, the marriage is already broken down. So that can't be the cause. It can be a consequence of the marriage breaking down.
So is it your position that the entirety of this relationship happened after?
Yeah, I don't think anybody disputes. Well, I don't know what they dispute. I mean, the judge wasn't exactly clear on why she ruled the way she did about that either. When she was talking about fault, the judge would say things like plaintiff testified A, defendant testified B, court's ruling C. It doesn't really tell us how she got there. The only thing that she said is that plaintiff has some fault in the divorce due to infidelity. Besides that, she didn't say why she thought that she should have 60% or why that was the right number, because it's a pretty big swing. Taking into consideration the amount of things that they were splitting up, it's $300,000-$400,000. It's a pretty big swing. But the defendant, she testified clearly that she found out about this in September.
Found out about the sexual relationship?
Yeah, the
But
alleged.
was there a relationship that was non-sexual between your client and the office worker before that?
According to her, according to her testimony, that
Her
was
being the defendant?
Yeah, the defendant. I apologize. And I believe her testimony was in 2010, 2011. So over a decade. And she tried to argue that there was a sexual relationship before the marriage that she found out about.
But what about this last one?
Yes.
I mean, there's three different women that are issue, right?
Yes. And the first one happened before.
Right.
The
But
marriage.
the last one you said.
That's the timeline is July. She asked for divorce, moves out of the bedroom. We're getting divorced. In August, sometime late August, he had a sexual relationship with the office person.
Right. But my question, stop right there. My question is, how long, what was he working with this woman that he ended up in end of August having a sexual relationship with?
I don't know exactly, but I know she's been there since at least 2015, maybe before
Okay,
that.
so I mean, my point is, the trial judge is capable of determining whether, even if they were not having a sexual relationship at the end of August, there was an emotional relationship, there was whatever going on, and that could have impacted, it been the last straw in July when the wife said, we're done.
Sure. But that wasn't the testimony. That wasn't the evidence. I asked the defendant explicitly at her deposition. I reminded this to her at trial. I asked her, I gave her the floor. What caused the breakdown in the marriage? Her testimony is she was tired of being picked apart every day for what she did, what she was doing, and couldn't do it anymore. She hit a point of knowing that he was never going to change. She never mentioned that infidelity was the cause of the breakdown in July. Her testimony was clear. She didn't find out until September. So months after the marriage relationship had already broken down to her. But also there's plenty of evidence that the marriage relationship had broken down years before that. There was extensive testimony about just the problems that they had during their marriage. And like I said, this isn't the first time she asked for divorce. It's the third time. These parties had been going at it for quite a long time. So I think that the courts, again, we have to do a little bit of inferring what the court was talking about, and the court said plaintiff has some fault in the divorce due to infidelity. Couldn't be talking about the September thing that she found out about if she had asked for divorce and moved out before then. If she was talking about the first time that she said something happened before the marriage, I don't see the relevance in that. They weren't married at the time, and it was a long time ago, 12, 13, 14, 15 years. And then the emotional affair that she says that Dr. Elter had, because Dr. Elter, his testimony was quite different. Even that was, I think, from 2010 or 2011. And I might have the year wrong, but it was somewhere around there, somewhere around 2010, give or take a couple of years. So I don't see how the court could have made that logical step to get there. And all we have to go by is one sentence from her opinion that says he's proved by a preponderance of the evidence that he has some fault due to infidelity. So one, I believe the amount that she swung at 60-40, I think is pretty high.
Didn't both parties ask for a 60-40 distribution?
They did, yeah.
Oh, so, okay, how's that high
Well,
then?
I mean, if you look at the cases that have dealt with the,
Who cares? Both sides said the other's at fault and we want a 60-40 distribution. She picked not your side and gave the 60-40 to the other.
she did.
You thought it was reasonable if your client got it.
Well,
You're right.
we did.
Yeah. I mean,
We also felt that we should have won that issue, but
yeah.
we're not the court, right? But in my humble opinion, and I believe that the case law backs me up on this to a certain extent, is that that's a pretty big swing. Because if you're looking at splitting up a marital estate, fault is one of the factors. There's a whole bunch of other factors that you're supposed to consider. We're not just determining something in a vacuum here, right? The third thing that I'd move on to is the valuation for the marital home that was given by the court. I reviewed the transcripts and the opinion again yesterday, and I still cannot stand up here and tell you how the judge got to the number that she did get to. I was trying to be creative and do different sorts of numbers, but I don't know how she got there. All I know is the number that she provided as the value of the marital home was lower than any appraisal that anybody submitted as evidence. The defendant appellee submitted 3 different appraisals, one from May 2023, one from June 2023, then one from January 2024.
I thought they ranged from 200,548 to 345,000. That was not the range?
Well, so what they were doing was subtracting this work that needed to be done, right? So the judge, because we filed a joint motion for clarification, trying to figure out what number to use, because I don't believe that she put it in her first opinion a number. She just said that the house was awarded her, they were going to split the equity. So we filed this motion, and then the judge explained that she meant to put, because she put the wrong year. So she said, oh, what I meant to do was use the January 2024 appraisal, which appraised it at $400,000 and subtracted $145,439.81 to complete the work.
Which her number was like 9,500 less than that.
Yeah, yep, roughly 10,000, but I don't know how that she got to that number.
But was there evidence that with the deductions, I guess, on the work, where one number was $200,548.11?
Yeah, so the first
Is that a
appraisal.
yes?
Yes.
Okay, well then, her number is in the range of proofs, right?
It's in the range in terms
It's
of,
between 250, 548 and 345.
correct. However, the judge did say that she was using this particular appraisal, and that she was subtracting that. So
The case law says that it's not clear error if you pick a number between the range of proofs.
that is true. So moving to the issue of spousal support, again, I think that the court got it wrong for several different reasons here. The first reason is even according to the court's methodology for determining spousal support, it was done incorrectly. I don't know. I'm sure that the court's familiar with the margin soft Craig Ross program that you use to calculate child support, and then it'll give you a recommendation for spousal support. So that was part of the motion for clarification, the joint motion that we filed, because she ordered spousal support, but she didn't indicate a number, an amount or duration. So at the motion hearing, she explained, or she subsequently issued the amount and duration, and then I filed a motion for clarification where the number came from, and she explained that she had her staff use the margin soft program. I attached the margin soft numbers as part of the appendix to my brief that shows that if you were to use the methodology that she explained that she used, then her number was still incorrect. Beyond that, the court again failed to really articulate why it was awarding the amount of spousal support, really to go through any of the factors. The court said that the defendant will need spousal support after the marriage to transition. And she didn't really say why. And if you look at it, in like the big picture of everything that was awarded, she awarded 5% interest on this award, this property award, that's over $1 million. The defendant is making over $5,000 a month in interest. If you look at the Michigan child support formula, the interest is supposed to be counted as income, as long as it's regular interest, as long as it's every month, then you're supposed to count it as income. So that would be an additional $60,000 to her income that wasn't added there. So the methodology was wrong, and there's no really clear explanation of how and why she came to the figure that we did. And I believe that issue should be remanded just for a little clarification, to maybe be able to speak more intelligently on what the court got right or what the court got wrong. The dissipation argument, I think, is the last argument from our brief. To that issue, I would rest on our written brief. I tried to spell it out as clearly as I could.
Okay. Any questions? Okay, thank you, Counsel.
Good afternoon, Your Honors. Jordan Ayler Smith on behalf of the appellee wife here. I do want to thank the court for allowing me to appear remotely. I always appreciate it when this court allows me to do so. As brother counsel rested on his brief on the dissipation argument, I will do the same and not make arguments as to that. I will rest on my brief. Your Honors, I think at the end of the day, what the trial court was trying to do here was to achieve equity. I think that a lot of the trial court's rulings that were made, as Judge Murray, you were walking brother counsel through, kind of the range of outcomes with regard to the value of the marital home. I think the trial court in several of its rulings picked numbers that were within the range of proofs for multiple of these issues to try to achieve the most equitable result possible. And I understand brother counsel's argument that the trial court stated it was ordering a 60-40 split. However, the trial court did actually award many of the assets 50-50. The trial court equally split many of these assets. I think, if I remember correctly, the trial court only split 3 on the 60-40 split. I think that is not a significant departure from congruence such that the trial court was required to provide a detailed explanation as to why the trial court was ordering as such. I also think that the trial court's factual findings, of which there are several, the trial court made findings on every single property division factor, are supported by the record, and brother counsel does not argue against them. Going to the specific issues, as to the judgment interest issue, my problem with that is that the 5% number didn't come from the trial court. It came from brother counsel, and he acknowledged that. There were 2 motions for clarification filed in this case, and nobody raised this issue of what interest rate was going to apply, what statutory interest meant. He just selected that number because that's what he thought he needed to do, rather than ask the trial court to clarify that in one of the two motions for clarification. So I think
Is statutory interest normally awarded in a judgment of divorce?
no, Your Honor, brother counsel is correct that statutory interest is not normally ordered. My point is more that they had the opportunity to ask the trial court about this and they chose not to, and instead decided to select a statutory interest rate on their own and are now trying to argue that as error to this court. Which is, I fleshed that out in my brief. I'm not going to belabor that point very much. In regards to the fault argument, I think that there was plenty of evidence in the record about why the trial court made the findings that it did. The trial court did make findings as to, you know, the burdens that were required on each party arguing the fault argument. In terms of the emotional affair issue, the 2015 date sticks out to me with this last affair that husband had, because that was the year that he paid for the divorce attorney for this, presumably what he was calling a coworker at the time. He then proceeded to have, you know, kind of a very intense texting relationship with this woman. Within days of, you know, the July incident where my client did move out of the marital bedroom, he was using pet names with this woman. He was telling her that he was in love with her. And this was, you know, months before the sexual relationship actually happened. My client testified that she did not believe the marriage was officially over and completely broken down until October of 2022, when the parties were terminated from marital counseling because of husband's surreptitious recording of their first session with their therapist. I think it's very clear that my client's position is that, you know, husband was at fault for the breakdown for the reasons that brother counsel stated, but also because of these multiple affairs that he had over the course of their marriage. And I think that that's very clear from the record, and I think the trial court's findings support that. In terms of the spousal support argument, again, I think this is a number that the trial court decided on because the trial court was attempting to do equity. My client had provided a monthly budget of, I think, $5,500 that she would not be able to meet with her income, which I believe was $1,600 at the time. Even with the spousal support, that is not enough to meet her monthly budget. And I think that the trial court's deciding to use that number rather than a number that was higher, as would have been necessary to meet my client's needs, was in a way to try to achieve an equitable outcome here. And at the end of the day, I think that is what occurred in this case. And I believe that the abuse of discretion standard is a very high standard. It does apply to this case. And I do not believe that husband has met that burden. And I would emphatically request that this court affirm this matter. And unless your honors have any further questions for me, I will stop.
Thank you, counsel.
Thank you.
Just a brief rebuttal to a few of the arguments raised by sister counsel. The 5% interest, statutory interest, that didn't come from me. I didn't decide that my client should pay 5% interest. The court explicitly said in its opinion, statutory interest. I was left holding the bag trying to figure out what that meant. And of course, my client didn't have any obligation to ask the court for clarification before coming on appeal. It did take the court about 7 months to issue an opinion after trial. Once trial was concluded, briefs were submitted, we waited about 7 months before we heard anything. So my client's decision to come straight to the Court of Appeals, I think was reasonable under the circumstance. The fact that she brings up about this alleged affair that happened in September, the last one, that he paid for this person's divorce attorney in 2015. What wasn't mentioned was that Mrs. Elter, the defendant, knew about that. This person was in like a domestic abuse relationship, and my client wanted to help her out because she was his office manager and she's valuable. I think there's testimony that he went through 2 or 3 office managers just recently before that. So this wasn't a secret. That doesn't imply that there was anything nefarious about the relationship in 2015. Now, the arguments that the defendant didn't believe the marriage was over until October of 2022, I think is completely self-serving, and I think it's contrary to the evidence that was at trial. The testimony was clear that in July of 2022, for the third time, she asked for divorce, moved out of the marital bedroom, never returned. Then she finds out about this, a divorce is filed, and I think being a little opportunistic, all of a sudden said, oh, I didn't believe that the marriage was over. That when I asked you for divorce, I wasn't serious about that. So I think that that is a little opportunistic. Sister counsel's arguments that she believes what the court was trying to do. That theme is littered throughout this entire thing. We believe that's what the court was trying to do because the court didn't really tell us what it was trying to do in a lot of these matters. The only thing that the court said regarding the fault issue was that plaintiff had some fault due to infidelity. Besides that, she summarized the testimony. If you read the trial court's opinion, it'll say, defendant testified A, B, C, and D, plaintiff testified A, B, C, and D. There's no connecting the dots or there's no credibility determinations. Defendant's brief, I think, says that the court made credibility determinations 13 times in her brief. In the trial court's opinion, it mentions credibility once in a matter that was related to a show cause motion filed subsequent. It wasn't related to the trial. So based on the evidence that was presented at trial, the trial court didn't mention credibility a single time. So the trial court could have said, I found this testimony completely incredible. I think that this is really what's going on. It didn't do that. So we don't know why the court ruled the way that it did in a lot of these matters. And I think that for that reason alone, I think a remand is merited. But I do believe that some of these issues should just be overturned because I don't think any sort of explanation would really kind of cure the defect. Awarding statutory interest on a judgment of divorce, I think the law is clear. It's not supposed to happen. So unless there's any questions,
Okay, thank you, counsel.
Thank you.
All right, that matter will be submitted. Moving on to item 22, the State of Greenwood, the Detroit Receiving Hospital, 374-598. Going for the hat trick.
Yes, good afternoon, your honors. Catherine Gossick on behalf of Detroit Receiving Hospital. I'm gonna try to keep this quick, seeing as it's been a long day. First and foremost, with this notice of intent issue, 2912B subsection 3 does not apply here. The standard is whether the claimant could not reasonably have identified Detroit Receiving Hospital, in this case by December 15th, 2022. Here, regardless of who you consider the claimant, it could have, Detroit Receiving Hospital could have easily been identified. The records clearly show that the decedent was transferred to Detroit Receiving Hospital from Riverview. He was alert, oriented, and involved in his own care.
And we know plaintiff had those records at that time of the complaint.
Yes,
That's undisputed.
that is undisputed, your honor, that the Riverview medical records alone provide that the transfer was to Detroit Receiving.
And that plaintiff had those prior to filing the complaint.
Detroit Receiving's records, your honor?
The records that show Detroit Receiving's involvement.
There's definitely showing that he was transferred there from
Right.
Riverview.
So
That-
those records, the Riverview records that show that
Yes,
plaintiff had before the
Yes.
complaint. There's
Yes.
no dispute about that.
yes, your honor. Whether or not they actually were in possession of the hospital records at that time, I'm not sure. But the Riverview records showing the discharge to Detroit Receiving Hospital was definitely in their possession at that time. And here, on top of it, the personal representative, who is the brother of the decedent, was also very involved in the care of the decedent. That shows throughout the medical records that he wanted to be involved in where the decedent would be transferred after the hospital. The emergency contact, who was the decedent's girlfriend at the time, was also very involved in the care. She was deposed in the underlying case and said she can't believe that Detroit Receiving Hospital wasn't sued because she thought they were most culpable. There was different avenues to reasonably have known that Detroit Receiving Hospital was a potential defendant in this case. But even assuming that that subsection applies, plaintiff failed to timely commence the cause of action. Here, plaintiff had to wait for the expiration of 91 days before filing the complaint. Plaintiff here filed the complaint early. And we can use whichever date plaintiff would want, either the May 17th date on the proof of service of the NOI or the bait stamp on the actual envelope showing the date it was actually sent out. Obviously, if it was May 20th, it was a couple days early. If it was a May 17th date, which is the day the unsigned NOI is dated, plaintiff filed it on 1 day prematurely. They did not wait for the expiration of the 91st date.
Let me ask you this, and I understand that this is not this case, at least your position is this case, but just, I want to make sure I'm understanding how all this works correctly. So let's say, again, not this case, but let's say that May 17th, that's the first time that they could have recently discovered Detroit Receiving's involvement. And they filed their notice immediately, as soon as they found out. It seems like, are they in between a rock and a hard place at that point? Because on the one hand, we have a 91-day period that we're saying that you can't file before, but that if you wait until the right time to file, you have a limitations period issue on the other side. Are those, in that circumstance, is that plaintiff just out of luck?
Your Honor, I think in that circumstance, I guess, depending on the timing of everything, there is a 6-month limitations period that could be used of when a plaintiff discovered or could have discovered a potential cause of action.
Because you think that 6-month discovery period would be the thing that would help a plaintiff in that situation?
As long as it's within the 6-year statute proposed, yes. And unless this court has any questions, I would like to save my time for rebuttal.
Thank you, counsel.
Good, I believe it's afternoon now, Your Honors. May it please the court, Logan Francisco, on behalf of plaintiff appellee here. I will be very brief. This case has a lot to do with the interplay between the statute of limitations, the death savings clause related to that, and then the notice requirements. We believe that the nails were hit specifically on the head here, for lack of a better term. This sort of timeline is very important. Taking the earliest date of accrual of these claims, November 26, 2019, provides our first look into what the statute of limitations expiration date is, which would be 2 years later, November 26, 2021. As this court is aware of how the death savings plan works, once the letters of authority were issued, which they were issued on August 16, 2022, Mr. Greenwood died during the original limitations period in April of 2020. The new statute of limitations expiration was then August 16th of 2024. In the meantime of those important dates, January 26, 2022 was the mailing date of the original NOI. That 182-day period expired July 27th, 2022. And the original complaint in this matter was filed December 15th, 2022. Now, as far as reasonableness of whether or not Detroit Receiving Hospital could have been identified, we did not have the specific Detroit Receiving Hospital records. The family themselves had not.
Did you have the Riverview records? Is that correct that that's undisputed? I understand you can dispute maybe the meaning, but did you have them in your client have them in their possession prior to the filing of the complaint?
I believe so, Your Honor, but I can't tell you for a fact.
Okay.
my understanding was that Riverview was included in the original NOI. I imagine we would have had some records as far as a merit review for the case, but I don't know specifically if we had records saying Detroit Receiving Hospital on it in the Riverview. For a myriad of reasons that I can't say one way or another, records are often cut off. I'm not making a claim as to that's being the fact, but whether we actually had those records, I do not know. But I do know we did not have the Detroit Receiving Hospital records. That Mr. Greenwood had passed away. He was no longer able to provide any explanation as to where he had been. Whether or not family members knew, that was not clear that they told the firm or the attorney on the case of he was for sure at this hospital. Unfortunately, there's a lot that's, we can't prove what people didn't know at the time. But once it was clear that Detroit Receiving Hospital was in fact a possible culpable defendant in this case, was when these processes were initiated. An additional NOI was sent out on the shortened notice period of that 91 days. It was sent, I believe May 16 was what we had put in our brief, which was what was on the actual mailing rather than, I'll just back up a little bit. And I address this specifically in the brief. There was a discrepancy of dates from when we were arguing the motion in the underlying court. There was the parties had assumed, I guess, in the purpose in for arguing that May 17 was the number, was the date. When looking back and actually preparing the brief on appeal here, the mailing was May 16, 2024 was the day it was mailed out. So with that said, the filing of our complaint after the 91-day period had expired, we were compliant with that. The second NOI was mailed out May 16.
Where do you get the May 16th date all of a sudden?
This was from the actual mailing of the NOI.
Which you didn't have before you filed the brief on appeal?
We did I believe just in the process of oral arguments, it was assumed that because, and again, I said this in my brief, the NOI was mailed. It became clear that the opposing party did not get that mailing. We sent it via email, this unsigned copy that had May 17 on it.
Counsel, you're on a review though here, I mean, that sounds like an argument that if you had it, belonged below.
Understood, Your Honor. Taking that into consideration, I understand. The 91 days expired on would have been August 15 or August 16. The complaint was filed on August 16. And then obviously there were two separate cases here, but we believe that plaintiff complied with the particular statutes here and how they've interplayed with each other. And with that, I'll rely on the remaining briefing if the court doesn't have any other questions.
Okay, good. Okay.
Thank you, Your Honor.
Thank you.
Your Honors, I'd like to address the May 16th notice of intent. The first time we heard of a May 16th notice of intent was the brief on appeal. That was not attached below. It was not discussed below, and it's not what we received. We received it was proof of service, May 17th, unsigned, but with the name of a Kimberly Bonowski. The May 16th NOI that's been attached to plaintiff's brief is signed by Catherine Jackson, but it's not the one that we received. And we have the actual envelope where the NOI was sent in, which has the electronic postage of May 17th and the bait stamp, postage stamp of it actually being sent out with the tracking information on May 20th. There's nothing that we received with the May 16th, and this is on appeal the first time we're hearing, and I think that argument is waived. So unless this court has any questions.
Nope. Okay.
Thank you, Your
Thank you,
Honors.
counsel. Thank you for your long day here today. Okay, that matter will be submitted. So moving on to the next item, it's number 24, Ismail v. Ali, 378-297. The appellant was endorsed for oral argument, but has waived it. The appellee is not endorsed for oral argument, so does not have that today. Ma'am, is that you? Okay. So I guess I understand your proceeding pro per, and I want you to know that we did receive your filings. We did consider them. I know we issued an order. One thing I just want to make sure that you're aware of is that our court it's not like a trial court. A lot of the work that we do doesn't happen here. We have oral argument on some of the cases. A lot of the cases we don't, for one reason or another. We spend an overwhelming majority period of our time back in our offices reviewing all of the matters very carefully on the filings that we have and on the records that we have. And that applies absolutely for individuals who are unrepresented like yourself. So I don't want you to think that because you do not have an oral argument here today, that your case is getting any less consideration from our court, or that it's not being considered with the utmost care and a fine-tooth comb. So please, I understand it can be difficult to navigate some of the procedural rules, and sometimes those outcomes can feel a bit harsh, but I do want you to know that we don't let that impede a full review and a full adjudication of every matter that's before us. No, I don't think so. I think we have everything we need. We understand, and that happens sometimes, and we understand. And again, that is that we are still capable of reviewing the merits of the matter and adjudicating it appropriately.
And you'll get a written opinion from us sometime in the near future. If your email is in our system.
How have you been receiving communicate? Yeah, however you've been kind of receiving materials from our court, that's how the opinion. Yeah, I would anticipate that. And you can confirm if you want to confirm with our clerk's office, you can do that as well. Okay. Nope, nothing further. Great, thank you. Okay, that matter will be submitted on the briefs. And item number 25, Inree Davis Minor, 376678. That also has no parties endorsed for oral arguments, so that will be submitted on the briefs as well. And that is that.